Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everybody.
Now, in a week where Wales appoints its first black male First Minister, politics continues to be tainted by donor Frank Hester's shocking and appalling remarks about Diane Abbott. Black women and, in context, women. We learn a South Cambridgeshire District Councillor, Heather Williams, received death threats even before the point she was formally elected. We really are at the most horrific point of abuse against councillors and MPs, and one can only speculate how long democracy will continue to be served by those reflective of their communities if something isn't done urgently. Coming up a little later in the podcast, I know you, Dennis, will be discussing malicious communications, but until then, we will turn our attention back to the local government news featured in our LLG bulletin. And we start with finance. Dennis.
Thanks, Helen. The Local Government Association has just published a new report setting out the learning from research and roundtables into 5 councils with experience of finance and governance challenges, which led to either a Section 114 report notice or a capitalisation direction with a governance review. Let's look further at this. The immediate causes of Section 114 reports and financial difficulties have been subject to thorough scrutiny and investigation, so it was not the intention of the LGA research to revisit old ground. Instead, the work examined published resources going back up to 5 years to identify anything that might have been missed in those official reports. This identified a number of themes that contributed to conditions that led to Section 114 reports or capitalisation directions. Now, the focus here is on strategic management issues, not governance from an organisational perspective. But the findings are interesting as they focus upon issues of risk, scrutiny, and scope for mitigating actions earlier in the journey that led to the formal action. And to improve the quality of strategic risk management, the report recommends that councils, 1, should adopt stronger approaches for the management of long-term strategic risks and ensure appropriate awareness of the knock-on impacts of such risks. 2, they should assign clearer roles and responsibilities for the implementation of mitigating actions. And 3, they should have processes to ensure that internal audit recommendations are addressed by the council's leadership. 4, they should scrutinise mitigating actions to ensure that they're implemented and have had the anticipated impact. 5, they should report transparently on where mitigating actions have been successful and unsuccessful in managing risk levels. Finally, 6, councils should be more explicit in the recognition of the severity of the risks identified. Now, there's much in this report to look at and which will better inform the LGA's approach to supporting the sector. This report will be of a special interest to lawyers working at the corporate level in their organisations. Helen.
Well, now turning to the regulator of solicitors, and the SRA wants our views on a suite of support for in-house solicitors. The SRA has developed a raft of new resources to support the 34,500 plus solicitors working in-house in England and Wales, and views are now being sought on the guidance and advice before they are formally adopted. Now, this has been developed in conjunction with the regulator's virtual in-house solicitor reference group. The materials build on issues which arose from their 2023 thematic review in working in-house and wider feedback from in-house solicitors over the past 12 months. The resources include a new document aimed specifically at employers, which outlines the solicitor's professional obligations and the benefits of employing a regulated professional. The resource is also designed to help solicitors establish a mutual understanding of what this means they can and cannot do for their employer. Other newly published guidance covers areas such as identifying your client when working in-house, handling internal investigations, and reporting wrongdoing by your employer. Alongside the guidance, they have published a number of case studies illustrating how it can be put into action. LLG have been attending meetings and talking to the SRA about the specific differences which relate to in-house local government lawyers. In relation to wider public interest duties, the SRA states that should any of these obligations come into conflict, those which safeguard the wider public interest take precedence over an individual's client's interests. This includes acting with integrity, independence, and in a way which upholds public trust and confidence in the solicitor's profession. You should, where relevant, they say, inform your employer of the circumstances in which your duty to the court and other professional obligations will outweigh your duty to them. Now, returning to a familiar topic on the podcast, the Information Commissioner's Office. Dennis.
Well, yes, indeed. Information Commissioner John Edwards has issued a clear warning recently to all public authorities about breaches of the Freedom of Information Act. This occurred as the ICO took further regulatory action against 5 public organisations for their continued failings to meet their obligations under the legislation. Here's more on this. FOI is a fundamental part of transparency. Getting it wrong can mean additional resources are needed to deal with complaints and appeals about decisions at a time when services are under sustained pressure and resources are stretched. It is in your interest to get it right. And ICO Commissioner John Edwards said he knows that many organisations are already leading by example, but as demonstrated by the enforcement action taken over the last 18 months, many need to do much more. Edwards called upon calling all public local authorities to encourage staff, whatever their role, to take FOI seriously. Dedicated resources are needed to improve access to information and transparency, and to ensure that you have the right training, processes, and culture in place. Leadership makes a real difference. The ICO recently published case studies that demonstrate how leadership has driven forward an open and transparent culture in those authorities. Edwards urged organisations to take a look and challenge themselves to see how their organisation compares. And he said, these are the key initial steps you can take. First, know what you need to publish and make as much information publicly available as possible. Next, look at what people are asking you about and actively publish it. Third, implement simple policies that show staff how to manage information requests effectively. Next, share the ICO's simple FOI in 90 seconds guide and response templates with staff. Next, provide mandatory FOI training for all staff and review it regularly and offer refresher training. Then, invest in tools and systems to manage and respond to information requests. And finally, monitor performance to ensure that your organisation is complying with its legal duties using the template action plans on the ICO website and its self-assessment toolkits. Now, this is, of course, an important message to all local authorities too. Failure to comply is simply not an option. Helen.
Transparency, the message there then, Dennis, unless, of course, you're asking for information to be released by the government in relation to the call for evidence. Then a promise to release it at some point in the future will suffice. I got slightly controversial there, Dennis, so let's move on quickly. International Women's Day, that was held on the 8th of March, and it also saw the House of Lords debate the motion to take note of the day and take steps to promote the economic inclusion of women. Now, the LGA had briefed vice presidents in advance of the debate on the good practice of councils promoting the economic inclusion of women, both in their communities as well as within councils themselves. The LGA states that it's vital that local government reflect the communities it serves. Women make up 76% of employees in the local government workforce, but still only 33% of councillors in England are women. Members' feedback that a lack of pension contributions, support for parents, and flexibility in how councillors can attend meetings, and the abuse and intimidation directed at those at public life act as barriers to women and other underrepresented groups standing for election or taking on leadership responsibilities. These points were echoed by Baroness Northover, who noted that high inflation and cuts have eroded the budget for public services, including local government, leading to real-term cuts, since women are more likely to use these services and work in them, it will necessarily impact them more than their male counterparts. On opening the debate, Baroness Ver of Norbiton said, "The evidence shows that investing in women and breaking down the barriers they face accelerates international development. That is why British international investment continues to champion gender-smart investing, and why it has pledged that 25% of its new investments in the period 2022 to 26 will focus on supporting women's economic empowerment." Speaking about pay inequality, however, Baroness Gale said, "Considering that the Equal Pay Act was enacted in 1975, how much longer do women have to wait to achieve equality of earnings? It has taken an awful long time to get to this stage." Now let's turn back to my comments at the start of the podcast, Dennis, and that case concerning malicious communications.
Yes, Helen. Finally, from me today, I want to turn now to a case that involved an alleged malicious communication sent to a local councillor. An appellant has successfully overturned his conviction under the Malicious Communications Act 1988 over an email that he sent to his local town councillor. And this is the case of the appeal which was allowed in the Crown against Thomas Casserly. Here's more on this. The appellant, Thomas Casserly, was convicted at Chester Crown Court after a trial of a single count of sending an indecent or grossly offensive electronic communication with intent to cause distress or anxiety, contrary to Section 1, subsection 1, paragraph B of the Malicious Communications Act 1988. Casserly appealed against conviction with leave. The complainant was an elected town councillor. The prosecution was based on the contents of an email sent to her by the appellant, one of her constituents, in which he challenged her ability to perform her public role. The appellant maintained that his communication was a legitimate expression of his opinion and that he was entitled to express his concerns in accordance with Article 10 of the European Convention on Human Rights. The appeal was subsequently allowed and his conviction quashed. But the key elements of the judgment are at paragraphs 48 to 49, and here is a brief summary of them. 1. Whether a message is grossly offensive is a question of fact to be answered objectively by reference to its contents and context, not its actual effect. 2. The question is whether the message goes beyond the limits of what is tolerable in our society. 3. The answer must reflect society's fundamental values. Those values include the great weight to be given to free speech, the need for tolerance of statements and opinions that some might find offensive or upsetting, and the special need for tolerance on the part of those in public positions. 4. The context of the speech must be considered, and in a democratic society, political speech is to be given particular weight. The Strasbourg jurisprudence identifies a hierarchy of speech, with political speech at its apex. The greater the value of the speech in question, the weightier must be the justification for interference. The proportionality assessment must include some evaluation of the kind of speech under consideration. 5. Accordingly, where freedom of speech in a political context is engaged and there is a case to answer, it is essential that the offence be defined in terms which reflect the enhanced meaning of grossly offensive. Finally, 6. In order to establish that at least one of the defendant's purposes was to cause distress or anxiety, it is simply not enough for the prosecution to prove that the message was likely to have that effect, and that the defendant knew or foresaw this, or that he gave no thought to the matter. The prosecution must prove that at least one of the defendant's purposes was to bring about that particular consequence. Now, the case will be of interest for the guidance it gives on each of these issues and the nature of the questions on which a jury needs to be directed, particularly around the issue of free speech. Helen.
And distinguishable, Dennis, from the vile abuse I referenced at the outset. A helpful judgment. And finally, from me, the Carers' Leave Regulations 2024, prepared by the Department for Business and Trade, come into force on the 6th of April 2024 and apply to England, Wales and Scotland. The regulations make provision to implement a new statutory entitlement to carers' leave for employees. and they entitle an employee to be absent from work on carer's leave, and they make provision for how the leave can be taken. The instrument ensures that the leave will be available to employees for the purpose of caring for a dependent with a long-term care need. It creates an entitlement for employees to be absent from work on leave in order to provide or arrange care for a dependent with a long-term care need. Entitles all employees who meet the eligibility conditions to take carer's leave regardless of how long they have worked for their employer. It ensures the leave will be available to take in increments of half days or individual days up to a week to be taken over a 12-month period. It does not require employees to provide evidence in relation to a request for carer's leave, that's important, and provides that employees taking carer's leave will have the same employment protections as associated with other forms of family-related leave, i.e. maternity. And this includes protection from dismissal or detriment as a result of having taken the leave. So the regulations are being made under new powers inserted into the Employment Rights Act 1996 by the Carers Leave Act 2023. There's currently no specific statutory right for carers to take time off work, although there are several other rights to leave on which a carer might rely, provided they meet the eligibility criteria. In contrast to unpaid parental leave, which is limited to parents of children under 18, carers leave will be available for a wider range of caring situations, excluding general childcare, except, of course, where the child meets the definition of a dependent with a long-term care need, and this leave entitlement will be unpaid. Now, employment lawyers should ensure that their council's policies accurately reflect these changes when they take effect, which, as I've said, is the 6th of April. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 10, available on the LLG website now. So it's goodbye from me.
And from me too.